Hi everyone, welcome to our KML Foundation Table Talk vlog. I'm Paul Stamiska, your estate plan counselor, and I'm really excited to come to you again because we're following up on last month's vlog. Now you might remember we were talking about asset protection last month, and in that discussion, Attorney David Strazy referenced trusts, and there were different trusts we talked about. We thought it might be worth having another vlog just specifically talking about all the different options that you might have to consider. And so, David, thank you for coming back again another month and be able to share this information with us. Let's start, first of all, a very basic question. What is a trust?
So a trust is simply a legal relationship where someone transfers assets to a trustee who then manages those assets on behalf of a third party who's called a beneficiary. Now I know it sounds complicated, but when I explain this to my clients, I like to think of it as kind of this umbrella that holds all of your assets. And you stipulate exactly what's going to happen to those assets, not only while you're alive, but also after you pass away. It's kind of like this big entity of sorts that holds all of your property. And it gives us a few estate planning goals that we can accomplish, including keeping things out of probate court.
That kind of sounds to me like it does the same thing as a will.
So actually, a will controls your assets through the probate process. A lot of people have the misconception that if they have a will, they will avoid probate, but it's really the opposite. What the will really is a roadmap for probate court that directs the court as to where your property should go.
And we've talked before about probate, and that's probably not what most people want to go through. And so, if I understand correctly, then the trust avoids probate?
It's one of the options to avoid probate, and what I like about the trust is, in addition to avoiding probate, it gives us a lot of other advantages as well. For example, this is where we can get a lot of that asset protection planning that we spoke about in the last vlog, where instead of just handing a check to your beneficiary if there's some problem, we can keep their shares protected. Okay? This is also where we can incorporate tax planning. So if estate or transfer tax would be an issue in a client's case, we can do planning in the context of a trust to reduce estate or transfer tax. We can also do some tax planning for your qualified accounts, like your IRAs, for example. So a trust gives us a platform to not only avoid probate, but do a lot of other planning, which most clients want to accomplish.
So it sounds like you can accomplish a lot with a trust. Is there one type of trust, or are there different trusts to do different things?
Yeah, different types of trust. The most common is a revocable trust, and that's the type of trust that's set up by you. You typically can serve as trustee of it, so you're in charge of it. While you're alive, you can take out whatever you want, whenever you want, and you can revoke it, amend it, modify it, basically do whatever you want while you're living. And that's basically like a glorified will, all right? During your lifetime, nothing really changes. Really, nothing will seem different. But when you pass away, that's when we can keep your successors out of probate court and get that protection planning and also some of that tax planning. Now, there's also irrevocable trusts that we would set up for specific purposes. One of which is if you have a very large estate that is subject to potential estate tax. That's one reason we would set up an irrevocable trust. And the other reason is that long-term care protection that we spoke about in a previous vlog, where maybe we're looking to protect assets from long-term care spend down.
So you referenced people with maybe a little bit more substantial wealth. Is the first trust, the revocable trust you talked about, do you really have to be rich for one of those too?
No, and I get that a lot where people think of trust fund babies and they think I need $50 million to set up a trust, and really that's a misconception. The revocable trust is something that I find is applicable to a lot of my clients regardless of the size of their estates, simply because all you need is $50,000, and if you exceed that limit, your estate could have to go through probate proceedings, and it's not uncommon where people want to at least avoid probate. And it's also not uncommon, regardless of how much wealth someone has, where they want to keep their shares for their kids protected if there would be some unexpected situation like a lawsuit or a divorce or potential long-term care for that child down the road. So that revocable trust is something that I use all the time, regardless of estate size.
So you referenced $50,000. I know I work with a lot of people that will say, I'm barely making my monthly payments. I don't have $50,000 in my checking account. I don't need a trust.
And I think those people are likely being modest. Once you look at the fair market value of your house and the face values on life insurance policies, and you factor in your retirement accounts, all of those things are potentially assets that could be probate assets depending upon how you have things structured. So it's very easy, just with a house alone, for someone to be over that $50,000 threshold. Sometimes people forget what they all own. I get that a lot in my practice, but a lot of people are in that category just with real estate of probate being a potential issue.
So what you're really saying then is it's about wealth, not just cash.
Correct. Yeah, we're looking at everything, even all of your in-kind tangible assets.
Okay, so it sounds like there are different options with trusts, and of course everybody has a little different situation. I mean, if they come to you and say, I need a trust, is this just like a boilerplate policy that you just fill in names?
That's a question I actually get asked a lot. And the fact of the matter is there's a lot of commonalities between clients, and a lot of these provisions are based upon current laws, and they are the same from document to document. Where we get into customization is more in distribution and where clients want their assets to go, in terms of who they want to serve as trustee, and there may be different situations that people are in tax-wise. So we're generally looking at different templates, if you will, but that's customized then to a specific situation. People are not as unique as they think they are, especially if you do this planning all day, every day. You see a lot of things repeat themselves. So there's not just one document that applies to everyone, but there's certainly planning that's across the board, and a lot of people fall into those different categories.
Okay. This is maybe a little different topic, but I know that people really are concerned about taxes, maybe in the spring. But there's so many other taxes to be concerned about, and one of them in our area is estate taxes. How does that relate with the whole discussion of trusts?
So estate tax planning is one area where we would look to an irrevocable trust, as I mentioned. However, right now the exclusion is $11.4 million. So you don't pay estate tax unless your estate's worth more than $11 million. That's going to sunset back to $5 million in 2026, but still a very, very high exclusion. Now that being said, I don't like to throw caution out the window. I mean, we don't know what the laws are going to be in the future. So there's planning that we can incorporate into marital trusts to plan for possible estate tax if the laws would drastically change, because that's a 40% tax. So if the laws would change, that's a pretty substantial check you're writing to Uncle Sam. So estate tax is not an issue for many people right now, but we have no idea what the future is going to hold.
Okay, so you indicated that estate tax only kicks in if you have an $11 million estate or more. A lot of people aren't in that category, but you also indicated that number might come down. Should people wait until that event maybe happens, or should they maybe create a trust now to be prepared for that?
I always recommend creating it now, simply because we don't know what mental capacity they're going to have in the future. They may become incompetent and they cannot update their estate planning documents. And a lot of people aren't reading scholarly articles on a daily basis about estate tax, nor do they always remember how their trusts were drafted. So I always advocate to have as much flexibility in estate planning documents as we possibly can today to plan for tomorrow. You know, that's good estate planning. We're not planning just for today. We're planning for some indefinite point in the future, and we want to plan for as many contingencies and variables as we possibly can.
Makes sense. So as powerful as trusts are, do I even need a will then?
So when we do a trust-based estate plan, we still have a will. It's called a pour-over will, and all that means is if anything does have to go through probate, it goes into your trust. But again, the concept of the trust is to avoid probate. So as long as we get all of your assets in the trust, The will is just kind of there as a backup. All right, that's why it's called a pour over. So it's just there for a rainy day. When we set up the trust, the next step is to get your assets into it. And if we do that, we'll avoid probate and we won't need the will and we won't need probate proceedings.
And again, help me understand this, David. If I come to you and ask for an estate plan that is not trust-based, so I've got the other documents, a will and other documents, I walk away and I'm done. But if I have a trust, I probably have more work that I have to do after I see you.
Correct. You're doing more work on the front end, and the concept is to save time, money, expense, and hassle for your loved ones after you pass away. So we do have to go through a process called funding, where we transfer the titles of your assets into the trust. That's how the trust works to avoid probates and to protect the assets and to plan for taxes. Now in Wisconsin, we do have some very good backup documents that we also sign, where you basically state everything I own is owned by my trust or goes into my trust upon my death without probates. And more often than not, those backup documents do work, but the best protocol is to update all of your titles and ensure that your revocable trust owns everything.
So if I understand correctly, you do have a little bit of work to do when you draft the documents, but you avoid a lot of work and hassle later on. So it does really sound like trusts are very powerful documents. You talked about some asset protection. You talked about being able to distribute to loved ones more efficiently and effectively, still having control of your assets, but making sure that they really are going to be able to go where you want them to go, and do it privately without a court or the public being able to see that. It sounds like they're really a valuable tool.
More often than not in my practice, we're basing an estate plan around a trust of some sort. I don't want people to assume that I force a trust upon all my clients because, again, it's very much based upon goals and what clients want to accomplish. But the trust is just a very flexible tool, and it can do a lot in the way of keeping things out of court, keeping things protected, keeping things out of the hands of the government and the IRS. So we use it a lot in estate planning practice.
Boy, David, thank you. Thank you very much for this information. Very practical. What I've learned is that there's a lot of complexities, but you have the ability to understand it, make it simple for me or people like me. And we really appreciate that. So again, if you feel like this is something that you need to pursue in your own estate plan, really encourage you to see somebody like David, an attorney who does estate planning and specializes in that, can help draft a trust that is appropriate for you, because it is your life, it's your plan, and it's your legacy. Until next month, we'll see you then.